We are kicking off tonight one of our town halls that will focus on bringing you the most up-to-date information concerning your rights in the United States. I'm delighted to be here with Milan Pham and Crystal Monique Richardson to go over a little bit of what we should be on the lookout for in terms of protecting our rights post-Roe v. Wade. As you all know, on June 24th, Dobbs v. Jackson was the final opinion on Dobbs v. Jackson came down from the Supreme Court that overturned almost 50 years of precedent regarding abortion access in this country. And when that ruling came down, much to the chagrin of our community, certain rights that were typically afforded under the Constitution were put into jeopardy given the interpretation that came from the opinion penned by Clarence Thomas. Milan and Monique, who are two of our lovely board members and also very talented attorneys, working to preserve our rights in the community and also working to ensure that we can do adequate estate planning to protect our loved ones, will be walking us through what we can do to keep ourselves safe in this new, I won't say it's uncharted territory, but it was certainly unexpected that our community would be facing the level of threat that we have at this current moment. So without further ado, I'm going to turn it over to Milan to kick us off and talk about what we can expect and what we can do.
Thank you, Kendra, and thanks to Equality NC and all of the work the ENC has been doing to protect our rights across the years. I'm going to start a little bit atypically for an attorney by having you who are on screen and off screen close your eyes for just 1 second and arrive with us here. If you're not an eye closer, just look down at your lap and your hands relaxing in your lap for 1 second. Drop away the stress of the day, the hurry, the hustle and bustle. You've just gotten off work. Some people like Kendra are still not off work. You're hungry. Maybe you've just eaten. You're stressed. We're getting ready to talk about a potentially stressful situation. You're going to learn some information about our community. And you're arriving with burdens and gifts of being who you are. Member of our community, an ally, a friend, an advocate. And you are arriving as a deeply resourced person. You are here with all of the gifts that were given to you by the people who preceded us, all of the strength, all of the daring do, all of the capacity, all of the community, your ability to make family in ways that the law has not anticipated, your willingness to stand up for each other. Just take one moment and be with that before we start. And when you're ready, open your eyes to the miracle of fate that is you, and join us in coming to understand the context in which Dobbs was decided, how that might impact our community, and what we can do to protect ourselves in the light of a Supreme Court that is, in the very least, hostile to who we are. I'm going to start by introducing my co-presenter, Monique. Monique, wave your hand. There she is. Monique is a longtime advocate for our community, a North Carolinian by birth, raised in the Charlotte area, went to UNC Charlotte. She is an amazing advocate and spent her years immediately after law school working for Equality NC, in fact, until she decided to open up her own law practice in the Triad, where she focuses on estate planning and will be serving as a resource for our community. She is also the chair of Equality in CPAC, the chief herder of us cats, and has been very successful in getting an unprecedented amount of work done with the PAC and in conjunction with Kendra. And I'm really pleased to be presenting with you today, Monique, and to be your colleague and friend. And with that, I'm going to hand it over to you to talk a little bit about our purpose.
You are on mute.
Thank you so much, Milan, for that very, very kind introduction. And it's a pleasure to work with you and Equality North Carolina as well. Equality North Carolina is near and dear to my heart. As many of you know, I've volunteered for ENC among other LGBTQ organizations. And so these issues are very near and dear to my heart. And I appreciate all of you for being here, taking the time to learn this information, to support Equality North Carolina. They are on the cutting edge of these issues. ENC is a great hub and resource for those in the community to understand the impact of certain legislative issues, political issues, judicial issues on LGBTQ North Carolinians. And so it is with that, and also being an attorney and really understanding that we are the conduit between the community and the impact of these laws and being able to change them so that we all can have a lived equality. And so I'm sure Milan feels the same way, that we feel very passionate and very much want to do what we can to make sure that we all have that lived equality in our state that we love. And so I'd like to start by introducing Milan, who is the partner of Nicholson Baum PLLC, which is a boutique law firm in Durham, North Carolina. This practice is centered on emerging issues of family formation and dissolution, including surrogacy, assisted reproductive technology, and adoption. She is an art fellow with the American Academy of Adoption and Assisted Reproduction Attorneys. In addition to managing her firm, she is a member of the National Family Law Advisory Council of the National Center for Lesbian Rights, and she serves on the boards of the Pauli Murray Center of History and Social Justice, as well as jointly with us on Equality North Carolina's board. So Milan, take us away and get us started.
All right. Thanks, y'all. I want to talk a little bit about the context of Dobbs and how we got here. I am relying on people who are attending to help disseminate accurate information on behalf of Equality NC and the legal advocates in our community. I think understanding how we got here is really important to understanding the protections that we need to seek for our community and what is at risk. You know that Dobbs overturned Roe versus Wade. The Supreme Court has repeatedly recognized the concept of liberty, and over time, it's advanced and enhanced its definition of liberty. Roe is just one of a line of seminal opinions where the Supreme Court developed the doctrine of liberty as a source of substantive rights encompassing everything from bodily integrity to child rearing to birth control, and most recently, and as we mostly understand it, to marriage equality. But all of the issues that have been protected in this seminal line have impacted our community. There are a number of legal issues that have come up, and the court has defined this concept of liberty as a procedural due process or Fifth Amendment right, or a substantive due process right, which was developed in case law, in which we understand to be mirrored in the 14th Amendment, which also guarantees equal protection. In order for you to appreciate the impact of Dobbs as a case and its impact on potentially Obergefell, you need to understand Roe and its context and its development, and what we understand to be liberty rights due to us under the Constitution, and which we claim as a community of LGBT folks. There are different perspectives on giving meaning to what constitutes liberty rights. One is only if a right is written in the Constitution or is deeply rooted in this nation's history does it exist. You've heard this over and over from people who are not supporters of our community. People who tend to support our community view rights as evolving over time and believe that while history and tradition guide us, they don't prescribe the outer limits of our rights. The later view is what's led to the recognition of rights that are not specifically enumerated in the Constitution. I know you've heard this on multiple occasions as well from originalists. Obergefell specifically rejected a history-bound method of identifying liberty rights, asserting that history and tradition guide and discipline this inquiry, but do not set its outer boundaries. Because if rights were defined by who exercised them in the past, then received practices could serve as their own continued justification, and new groups could not invoke rights once denied. There are a number of cases, many of which you've heard, some of which you haven't heard. They impact everything from procreation to contraception to marriage and child rearing rights. Dobbs itself was overturned in a 6-3 decision. The majority included Alito, Thomas, Gorsuch, Kavanaugh, and Barrett, and concurring were Thomas, Kavanaugh, and Roberts. Roberts concurring only in judgment, and dissenting were Breyer, Sotomayor, and Kagan. And I talk about this not because I'm trying to give you a primer in constitutional law, but because it's important for you to understand where we're going. Attacks on the right to abortion since Roe was decided have increased significantly. They've always existed, but they increased significantly in 2010. Trap laws, biased counseling laws, rules saying you can only get an abortion at a hospital or by a doctor. There are laws that say fetal remains have to be buried, and there are laws that address how long you can get an abortion. And the law that was at stake in the Dobbs case was a law that banned abortion after 15 weeks. Originally, Dobbs was not seeking to overturn Roe, but in the merits briefing, when they realized that they weren't going to have a Supreme Court in their favor, Mississippi changed its course and said, in fact, we do want you to address more than the Mississippi law. We want you to also address Roe and seek to overturn that. Dobbs is the first time in the court's decision that it's made a decision to deprive us of a liberty right in the long seminal line of cases that I've referred to. The majority opinion limited the Dobbs decision to abortion. But what you know is that in the concurring opinion, Thomas made an open call to reverse all intersecting liberties, except conveniently interracial marriage. And so what we've got is we've got the majority opinion saying if a right isn't in the text of the Constitution, it's not deeply rooted in our history, it doesn't exist, and abortion is neither. And then concurring opinions calling for attacks on our community among many other communities. The dissent said forced pregnancy is in the offing. Either the mass of the majority's opinion is hypocrisy or additional rights are under threat. The assurance that Kavanaugh provided about other rights not being at risk rings really hollow, and no one should be confident that this majority is done with its work. And why does that impact us? Because Obergefell is the end of that line of the seminal cases that have expanded our liberty rights. The National Family Law Advisory Council of the National Center for Lesbian Rights believes that it is possible that a case will percolate up to the Supreme Court within the next 2 terms. They also believe that states will be chipping away at the rights of LGBT communities similarly to how they chipped away at the rights to abortion, and there will be a tsunami of anti-LGBT legislation, which we are already seeing. So a confluence of those strategies, we believe, is the goal. And we're looking at needing to protect ourselves in many different areas: healthcare decisions, the ownership of property, estate planning, etc. One issue differentiating Dobbs from Roe is that Roe was decided only on procedural due process, and Dobbs has a equal protection component that Roe didn't have. And a lot of legal advocates are hoping that this protects us. And what we believe is that we can't be over-prepared as a community, and we cannot overprotect our families. This is not a new path for us. We have all the tools that we need to protect ourselves. It is a crying shame that we're going to have to do it at this moment, but we're amply prepared to have to do it. And Monique is going to start by talking to you about estate planning protections. Am I within my time frame, Monique? Excellent.
You're right on time, Milan, and thank you for what you shared in regards to Dobbs and how we got here. I think that's important context for this discussion today. And so where Milan was talking about some of the importance of the Supreme Court cases, I want to give an overview about some of the cases that are coming up, because these are issues that the type of cases that they're addressing are issues where we thought were essentially well settled into law, stare decisis, precedent, things that we could absolutely count on as issues arise and as we try to gain protections, not take them away. And so some of those upcoming Supreme Court cases involve things like voting rights, elections, public accommodations, and issues dealing with the First Amendment. So and many more cases. These are just a few that I wanted to hit on so that folks have a really good understanding that cases and issues that the Supreme Court has avoided or tried to skirt in the past are being addressed in the court, and they're really changing some of the fabric of what we deem to be, fair, just, and really challenging our democracy. And so one of the cases is an Alabama case where voting rights is an issue. There, the court could further reduce protections for minority voters. And this is its third consideration in 10 years in review of the landmark Voting Rights Act. Again, the court is reviewing cases that are well settled for the past 50 years, particularly those that were substantiated during the civil rights movement. They've been chipping away at voting rights, and this has been a issue that before the court for the past decade and more. And so it's not getting any better. So in this case, Alabama has 7 congressional districts, has a Black majority, and a 3-judge panel has agreed that the state should create a second district with a Black majority. But the Supreme Court has halted any actions or changes to their legislation, saying that it wants to hear this case. And so that issue is before the court. A North Carolina case is before the court. As we know, we've had issues with congressional maps where this has been debated in court over the past several years. And so one of the parties has asked the court to essentially adopt a very unique legal concept. They're calling it an independent state legislature theory. And that basically removes the North Carolina Supreme Court's oversight of elections in Congress. And so the issue arose there where North Carolina, of course, ruled that the congressional maps that were created were essentially unfair because it gave one party a very lopsided disadvantage, and then adopted and approved very even maps among the 14 congressional districts that we have here in North Carolina. And so the issue that is before the Supreme Court is whether the courts have authority to play a role in congressional elections, and that includes redistricting. So that's a very important issue when it comes to accessibility for voting rights. And then again, we're revisiting cases like the wedding cake case. There's a case 303 creatives, where a graphic and website designer in Colorado wants to expand her business by offering wedding website services. And because of her Christian beliefs, she has on her website up front that she would decline any request for same-gender loving couples to design wedding websites for them. And so again, the court is being forced to look at issues that historically they have skirted over the past 5 years. And so the ruling that they have in this matter will really bring to the forefront rights in regards to religion, free speech, and public accommodations. And so when we think about Obergefell and its impact, and whether that could be a potential case that would come before the court over the next several years, we want to be prepared for the worst, because again, they're doing unprecedented things. And the best thing that we can do is to put protections around the things that normally would be protected if you were married and if the court recognizes your marriage. And so I wanted to talk a little bit as well about what marriage is and some of the benefits. Of course, marriage has pros and cons. There's certain tax benefits and certain duties and responsibilities you have towards a spouse. And so it can impact your housing, insurance benefits and rights, healthcare benefits, spousal child support benefits, inheritance rights, funeral instructions, disposition of remains, and Social Security and things like that, other public benefits. And so those things are very important, especially when you are building your family. You want to make sure that they're protected. You want to make sure that they're provided for. And you can do that regardless of whether by operation of law your marriage is valid. Everyone over 18 has the right to create a will and other estate planning documents, which I'll get into here in a second. But it is your right to create an estate plan where you anticipate and arrange your assets and your estate and get your affairs in order in a way that aligns with your wishes and how you want things to be done towards your end of life, or if you become incapacitated and can't make decisions for yourself. And so estate planning is an opportunity for you to really utilize that right to self-determination, to be able to name individuals and to be able to perhaps restructure some of your assets so that they're protected in a way that you think will provide for your family, not just now, but for future generations as well. We've all heard horror stories where pre-Obergefell, pre-Windsor, accessibility for partners, let's say, for example, your partner's in the hospital and they're incapacitated, can't make decisions for themselves, and they didn't do any estate planning. Their family isn't necessarily supportive of your relationship, and there may be accessibility where you can't go in and be with your partner because you're not, in close relation or close kin to them. And so these estate planning documents will help you plan around some of those circumstances so that your chosen family, the people that you love, are able to make those decisions on your behalf and to be with you. We all have heard, again, horror stories about, especially within the LGBTQ community, where if your family isn't supportive and they make decisions contrary to how you present, how you identify, that can be horrific to, just honoring your life and how you want to leave your legacy. So I always encourage everyone to have an estate plan, but especially if you're in the LGBTQ plus community, I just think it's even more critical to being able to have your wishes upheld. And so 5 estate planning tools that you can do, very basic to start, is to create a last will and testament, a healthcare power of attorney, a general durable power of attorney, advanced directives, and sometimes people will create trust. And I'll talk very briefly about what each of those documents entail, but I encourage all of you to get with an attorney to talk about your specific circumstances and needs to create these documents and make sure that the document create aligns with what you desire. And so the last will and testament allows you to provide family information so that you can recognize in a legal document your family, even if the law doesn't provide for that. You can also provide instructions about estate administration. You can name your personal representative or executor. You can disinherit unintended beneficiaries so that, you know, that third cousin you've never spoken to or whoever doesn't inherit your belongings. And it's not the person that you would want to have those things. You can transfer any tangible personal property, any real property. You can even name a guardian for minor children if something were to happen to you and your partner. Those things aren't binding in regards to custody, but they're absolutely very influential in determining who would be guardian of your child if something were to happen. Again, there may be certain special circumstances where you may want to create a trust if you have, special needs, if you have a, individual, if a trust, I'll say this, gives you the ability to do more managing, not just who you want to transfer your belongings to, but it allows you to really manage your assets and essentially decide more about the control and how it's maintained for future generations. The other documents, like the healthcare power of attorney, informs your healthcare providers, physicians, hospitals, any type of entity where you're getting healthcare about what person you've named to make those decisions for you if you become incapacitated. You can also name alternates for the person that you name as your agent. Those types of documents are also important for naming whether you want to stop or start life prolonging measures, for example, any artificial hydration and nutrition. You can also leave a document with specific instructions for your healthcare power of attorney. So that way they're not guessing what you would do in those circumstances, but you have it documented. And I also recommend, in addition to creating these documents, that you have a really thorough conversation about your wishes with all of the agents and the individuals that you have named in your estate planning document, so that, again, you don't want them to have to go through the process of grieving and try to make those decisions for you. Other ways you can protect yourself is through parentage, which I'm going to pass to Milan to talk a little bit about how to protect some property assets and as well as your parentage rights.
Great. Thanks, Monique. I appreciate that. I'm going to talk a little bit about parentage, which has opened up significantly for us since marriage equality. The days before we had marriage equality, same-sex couples were not always able to be parents of children who they'd planned for, and sometimes had even given birth to, couldn't have their partners be parents to those kids. One of the benefits of marriage equality significantly to our community was the benefit to access a step-parent adoption. Have the court determine that we could both, if we're married and we have a child inside of our marriage, or if we're adopting, we could both be legal parents to one child. So I'm going to talk briefly about parentage so that you understand the context of parentage in North Carolina and what you need to do. There are over 3,000 references to spouse in the Internal Revenue Code. So what that means is that there are not enough legal documents to replicate that. And we can't bind the government, but what we can do is we can reflect clearly and carefully in our estate planning, in our agreements with one another, what it is we intend for our family, and using contractual principles, et cetera, provide some protection in the event of the reversal of Obergefell, We have Obergefell now, and so there are things that our community needs to do in order to protect the rights that we have currently. In North Carolina, there are 2.5 ways to be considered a parent. One is that you're a genetic parent. The other is that you are a parent by order of a court. And the halfway is that you're a statutory parent. And I say half because we don't have a case confirming that statutory parentage applies to us in the LGBT community. But we believe that based on legal reasoning, sound legal reasoning, that we should be considered statutory parents. 49A1 is our ART statute. And that statute basically says, and it's very gendered, so I'm going to tell you what it says in its gendered way. If a man and a woman are married and they agree in writing to the use of heterologous donor sperm, then they're both legal parents. In 2018, after Obergefell, the North Carolina General Assembly saw fit to pass a technical corrections statute to try to address the issue of gender in our general statutes. And they basically said, wherever we said husband and wife and man and woman in that context, we meant spouse and spouse. So 49A1 overlaid with the technical correction statute should mean that for LGBT couples, when there's a child born into the marriage, that both are legal. The problem with relying on that in North Carolina, we have a presumption of parentage. So if a child is born, say I give birth to a child, my spouse is going to be considered the legal spouse. It is a presumption of parentage that is rebuttable by evidence that you are not a genetic spouse or you do not have an order. If we were indeed statutory parents in North Carolina under 49A1 and the technical correction statute, then we would be able to say that. But what it doesn't do is it doesn't protect us if we cross state lines, so there's no portability to that parentage. So what I'm recommending for people who are parents right now, raising children who were born during the marriage, you're on the birth certificate. Birth certificate is a presumption of parentage. You need to get an order formalizing your legal parentage. In your estate planning, you need to talk to your estate planning attorney about the non-genetic parent being added as the guardian. Typically, the guardianship provisions in estate planning documents say, if my spouse does not survive me, then I name this person as a guardian. For the LGBT community, you need to back up a few steps, and the non-genetic spouse needs to be named as a guardian first. For additionally, just to tag on to what Monique has said, you'll need to have a specific definition of issue in your will to draw in your issue, your children who are not genetically related to you. So for instance, if Monique and I were married and I gave birth to a child, inside of that marriage, Monique's will would say issue includes any child born to Milan, to draw that child specifically into the line of inheritance in the event that Obergefell is reversed. So we're just layering on the protections for our community. So any person who is not genetically related to a child needs to have an order of accord, either a step-parent adoption order or a declaration of parentage. You want to go to a qualified attorney to help you with that. Additionally, a lot of us are getting married and we're getting prenups. We're getting married because we can. We're getting prenups because we recognize that sometimes we don't want the operation of law to become engaged, meaning that we want to have a choice about what happens with our assets in the case of dissolution. All of those documents reference marriage. If Obergefell is reversed and marriage equality no longer applies to our community, then it's going to have an impact on documents that reference spouses. And so any attorney who is drafting for you should also be addressing the issue of what happens in the event that there's an involuntary lack of recognition of your relationship. So they should be addressing what happens in the event that Obergefell is reversed. And any qualified attorney should be able to help you walk through provisions that protect you from an involuntary non-recognition of your marriage, as distinguished from a voluntary dissolution of your marriage or an ending of your relationship, because both will need to be addressed for our community. So prenups, postnups, you need to make sure that your marriage is protected and continue to be seen as a partnership. The contracts continue to be valid in the event of a dissolution of marriage, and so long as you intend that they be recognized and honored. These are steps that we took before marriage equality, and now we're just sort of revisiting them. We're both enjoying the benefits that marriage offers us, and we're also making sure that we're protected in the event that we no longer have those benefits. Questions that I have received about orders and agreements are, well, what happens if we get a birth order? What happens if we get an adoption decree and Obergefell is reversed? Those orders and decrees should still be valid. There are strong prohibitions against ex post facto laws. People who are married, their marriages actually should continue to be recognized. We will be in a very weird state of being where some of us will have been able to get married and some of us will not be able to get married. Orders that have already been entered should continue to be recognized. And so for that reason, we're advising that people go ahead and get their parentage orders sooner rather than later. And always for our community that we have an estate plan created. What is the likelihood, that we're looking at a case that brings down Obergefell in the next couple of years? NFLAC, the National Family Law Advisory Council, believes that it's highly likely that we're going to see a case that is filtering up to the Supreme Court to challenge marriage equality rights. We've already seen state legislatures and anti-marriage advocates across the country queuing up potential cases. And so we're moving forward expecting that we're going to be looking at some challenges. There is the Respect for Marriage Act, which is pending. It was surprisingly supported by a number of GOP senators. We had 47 GOP senators supporting it, and 157 opposing it, and 7 who declined to vote. And so on that math, we need 10 to pass. And thus far, some of our allies have come forward. So we've got Susan Collins from Maine, Tom Tillis from North Carolina, Lisa Murkowski, Alaska, Ron Johnson, Wisconsin, and Rob Portman, Ohio. But we still need 5 more to codify marriage equality, which is what the Respect for Marriage Act would do. And because we're facing an election shortly, the vote was delayed until after the election. And so this election matters significantly. Monique, do you have additional information that you want to provide about?
Yeah, I mean, to your point about the upcoming election, I mean, I just spoke about some of the issues that were up before the Supreme Court, but even here in North Carolina, we're still fighting for certain protections in employment, public accommodations, et cetera. I think it's important for us to reach out to Equality North Carolina for resources and just be aware of some of the information that they're putting out in regards to, for example, our voting guide. There's a very thorough process in speaking with some of the candidates about these specific issues, understanding that we are an organization that's pro-equality, and we want to make sure that we are identifying those who align with those issues. And we've seen a number of issues in North Carolina arise, specifically targeting like transgender individuals, gender nonconforming individuals. And so I think it's important that we are aware of those who really understand that we want to uphold those non-discrimination protections. We want to be able to have equal rights. We want our children to be able to, thrive. We have a lot of there's a lot of data out there in regards to, suicide rates and mental health wellness and things like that when it comes to LGBTQ communities, because of the impact that some of these various issues that we're talking about has on us, in our lived experiences. And so when we're thinking about, the state that we live in and the state that we love, we want to make sure that these issues that are going to impact us for the next several decades, these are laws that and rules and regulations that will all be have to work within. If we have a conflict or an issue or a matter where we have to take it to court legally, it's going to impact you because of who we elect. It really matters in regards to the leadership, in regards to some of the Supreme Court justices that we are electing, the folks we're sending to Congress. And I think that's why we see so many tactics to take away certain rights, to take away your accessibility to voting. And that's to continue to kind of chip away at laws that should be secure and that have been secure for a while. But as you can see, the tide is changing. And so, we get on these webinars because we want to share as much information about what the direct impact and the result of some of these elections could be as it relates to your lived experience here in North Carolina. So we hope that you'll continue the journey with Equality North Carolina and share with people that, some of the things you're learning, and just continue to be living your authentic lives, to be visible and show that we are out here and that, we matter, and vote. That's right. Kendra just messaged, and vote. It's very, very important. So anyway, I'm off my soapbox about that, but I really wanted to give some context about how beautiful it is that you all are here and really taking in this information tonight.
Are you ready for questions, Monique?
Yeah.
Okay. If anybody has questions about either estate planning or parentage, those are the two substantive areas we've discussed. I'm also happy to talk about property agreements, which is really what a prenup or a postnup might be. Specifically as it relates to our community, we're happy to take some quick questions.
Hi, Milan. My name is Matthew Turpin. I've really enjoyed both you and Monique's presentation, and I was just curious if anyone would like to talk about second parent adoptions.
Hey, Matthew. It's good to hear your voice. I will talk quickly about second parent adoption. North Carolina does not have second parent adoption. There was a period prior to marriage equality where we were getting second parent adoptions because judges were willing. Some very supportive and forward-thinking judges were willing to interpret the law in such a way that they believed they could enter orders of second parent adoption. But the Bozeman case, which was a case involving a member of our community, overturned second parent adoption for Senator Bozeman specifically in that case, but advocates came to understand it to mean that second parent adoptions were not safe for our community generally. Because of marriage, we do have access to step parent adoption, which doesn't make a person a step parent at the end of the day, but it's just the procedure by which an adoption occurs. And a step parent adoption occurs and is permitted because the person petitioning is married to the legal parent. And so that's one of the ways that marriage equality has really benefited our community and specifically children in our community. And so step-parent adoption is one of the things, Matthew, that I'm recommending that people do during this period where we are looking at no clear threat to marriage equality, no impending known clear threat to marriage equality. The other option that members of our community have, and which gay men have been mostly taking advantage of for many years because they've not been able to give birth at this moment technologically to their own children. Although I understand that Duke has got a uterine transplant program, they've gotten declarations of parentage, petitions to declare parentage, and we are now getting able to get petitions to declare parentage for lesbian parents as well who give birth. And some people find that more palatable because it really is just asking a judge to state what the law already is, which is that there are two parents to a child born in a marriage, and it does not matter whether or not they are different sex or same sex because of the Constitution, Obergefell, and the North Carolina General Statutes, which then makes that parentage portable. Does that address your question?
Yes, it does. Thank you very much. I've learned a lot from tonight. I really appreciate y'all putting this on. So thank you very much.
Absolutely. Looks like I got, oh yeah, I got a chat from a friend who asked me to talk about the possibility of second parent adoption in other places. So some members of our community were not able to get adoption before marriage equality, and then they split up and they aren't getting back together in order to become legal parents of their children. Or, they were never planning on being married anyway, but they both want to be legal parents to their children. And so we do have an option for you. If you're that member in our community, you don't want to get married, or because marriage isn't your thing, or, you've already split up with your co-parent and you're not getting married in order to be a legal parent, we can send you to Florida for second parent adoption. The Florida adoption statutes have a jurisdictional loophole that we've been able to take advantage of with a member of our community, one of the attorneys on the National Family Law Advisory Council to the National Center for Lesbian Rights, who can get second parent adoptions in Florida for unmarried people. This benefits actually not just our community, it benefits people who are in other family formations, a sister, two sisters raising one child, for instance. Blended and intergenerational families really benefit from this as well. But we can get an adoption decree for people who are not married and who are not related to each other for one child. And it's a second parent adoption decree, and it is due the full faith and credit of the Constitution and recognized in every other state. You do not have to go to Florida for the hearing. It takes place remotely. So, if you know people who need a second parent adoption, in reality and cannot take advantage of a North Carolina step-parent adoption or a declaration of parentage because they aren't married, then feel free to send them my way. And, well, I'll make an introduction with our colleague. I'm going to throw my information up in the chat for you just in case you decide you need to contact me. Just throw my email up here and my office number. Anybody else have any questions about estate planning or parentage? Property agreements, prenups, postnups. I think those are all the issues we covered tonight. So I just got a direct message asking about, do all these paths to protection cost money? Are there organizations that assist? Monique, Kendra?
I was thinking about legal aid. I mean, I know I have a virtual office. I can assist folks with estate planning across the state. I don't have a lot of overhead so that I can offer reasonable prices. So, and I'm willing to do payment plans. I do offer flat fees for the basic estate planning documents that I spoke about today. So, I want to encourage folks to, speak to an attorney, whether it's me or someone else, about their fees, because they may be more affordable than you realize. But in regards to free services, I believe, I want to say legally, but I'm not sure if this is one of their areas that they offer free legal services, but I think they would be a great resource to check. And then there is a website that I really, really, really enjoy. It's American Council for Trust and Estates Council, ATAC. And so if you're looking for resources, they have, videos, YouTube videos and things like that, where attorneys and their fellows are explaining a lot of the issues and expounding upon some of the issues that we brought up today. So that may be a good hub for more information as well.
Yeah, I'll jump in. I know that in response to Dobbs v. Jackson and some of the wave of the attacks that we've been having, we've had over 450 bad bills this year targeting the LGBTQ plus community. That legal aid was beefing up in several states their support of the LGBTQ plus community by focusing more broadly on some of these issues. Additionally, if you'll give me a moment, I'm just trying to get to another page. We have a resource that we offer at ENC called freewill.org. I would still recommend that you consult with an attorney to know the best way to set up your estate planning for that, but it allows individuals to basically set up and execute wills and leave inheritances and things of that nature. And it is a free resource to get you started in that process. But because of the intricacies of the LGBTQ plus community, I'd also recommend consulting a lawyer as you use that resource to prepare it. But it has the structure, also allows for you to leave resources to nonprofits like Quality and Seam.
Mm-hmm. Yeah. Unfortunately, I don't know of resources for parentage, only because it's such a complicated practice area. What I can say is that our firm does routinely provide low bono and pro bono services. We keep a low bono, pro bono docket throughout the year. And it is reserved exclusively for our community. Period. So, I don't, if there is some reason someone cannot afford to protect their rights, to parent, you should send them to the firm and see whether or not we can take them lo bono or pro bono. And we have been in conversation with the Pauli Murray Center for History and Social Justice about, in the very least, a DPOA, HCPOA clinic for LGBT folks. And, I've been talking to my team about whether or not we would do some sort of a low-cost clinic opportunity for people to file their own step-parent adoptions and have us help them walk through that process. There are a lot of logistics involved from a malpractice and legal standpoint that we have to figure out, but we are talking about it in recognition of the ways that our community remains unable to access services, and thereby, we're undocumented in ways that are significant. Yeah. Thanks for that direct message. Anybody else have any questions they want to share? All right.
You get any other?
Sorry, there is one question. I keep trying to go off mute, but it's that time of night. Someone wrote, it seems that the battle against those, including SCOTUS, who want to deny us equal rights, is occurring on a state-by-state basis. So there will be welcoming states and unwelcoming states, resulting in a mess if we move to unwelcoming states. How will our community's rights become all encompassing across the country?
So federal legislation is one way. Another way is through the Uniform Laws Commission, which is a commission that seeks to pass uniform laws across the United States. One example of that is the Uniform Parentage Act. That's the act it's an act that's been passed in, I think, 15 states at this point, and it provides really, really broad protection for emerging families. This is a issue area sort of approach, but if they're going to throw everything at us, we also need to throw everything we've got at protecting our own community. And part of that has to do with electing people at the state level who are going to proceed and promote our agenda. Even when it doesn't clearly seem like it might be our agenda. We've been at the Bar Association, through the Bar Association, working on trying to get this Uniform Parentage Act passed for over a decade at this point. And it just has not been the right time in the General Assembly to bring it. In large part, and these are some of the conversations we have, because it waves a giant rainbow flag, the act in and of itself. And there's concern that putting it in front of the General Assembly is targeting the weaknesses of our community in some way, to say, hey, look, you didn't realize this is a problem for the LGBT community, but let's show you what that is. So we do have a lot of work to do at the local level. It's one of the reasons, why we really ask people to support Equality NC. We're getting local LGBT and LGBT friendly electeds everywhere, so that we can work to promote our agenda, which is an agenda that protects everyone. And I'm going to throw up in here donation link.
You're nailing it. You took some of the words right out of my mouth. When it comes to some of the federal laws, like it would be great if we could get the Equality Act passed, and we got that, the Marriage Equality Act passed and things like that. It's just really important. And to your point, Milan, I think strategy wise, we've always tried to, of course, get federal protections passed, but when that doesn't work, then we work at a more state and local level. And so that's why it's important to have the right leadership, folks who align with pro-equality, so that we can have those protections. And the only way really to do that is, the federal law is the law of the land that all 50 states have to adhere to. And so again, it's important to make sure we vote so that we send the right people to Congress and make sure that we get these federal protections that we desperately need.
I'll go a step further and just say that, it's important to note that a lot of the judges that are deciding on our cases are appointed. So in addition to, getting out and voting, getting engaged, you need to make sure that you are voting up and down the ballot. And that also when things are up and under challenge, that you make your voice known. When there is any kind of contentious issue, our opposition is out in droves, bombarding electeds. And frequently we are silent. So not only do we need you to work with us to help get some pro-equality candidates elected so we can hold on to what little rights that we have, but we need you to stay engaged throughout the year, to take the opportunity to let your electeds know that, hey, this is something that impacts you. We need legislation on this. And that includes, that's on both sides of the aisle. They need to hear from everyone that there are issues that need to be resolved. Some folks will not be moved by that, but there are many people who will, because ultimately we do still have career politicians. And when they see sometimes that the tide is changing and they need to move, they begin to listen, but they don't listen if we're not using our voice.
Thanks, Kendra. And I've put a link in to donate to Equality NC. There's no, of course, fee for attending and or listening to this spiel, but there is a deep need for the work that Equality NC is doing. And so any gift you can make, no matter how small, is going to go to that work and to changing the landscape of the lives of our people across the state. So I really encourage you as you think about your giving, as we're approaching the end of the year, that you think about Equality NC. Oh, and in your estate planning, if you want to leave a legacy gift, I encourage that as well. I think, and you can find some information about how to do that, hopefully on our website. Is that true?
Yes, you can. I dropped the link in the chat as well. It also goes out pretty periodically to give people the opportunity to use that resource. But I also want to say, because I realize that not everyone has additional resources to spend, we take human resources. We need people. This Saturday, we have a huge Canvas Day. Sign up to knock on some doors and talk to people about why we need pro-equality electeds. We still have a few phone banks that are running up into the election. We train you how to do that. And we need folks to do visibility for candidates as well on election day. So there are many ways. We also have some paid opportunities for folks who want to do some poll protection on November 5th. So just, if you don't have financial resources to give, which we love those, we do, just get engaged, because literally your rights depend on it. And we're working to stave off every attack and monitor every trend that's happening and to mobilize people to fight for their lives in this moment.
I just want to thank you all again. I know I've mentioned that a couple times, but we really appreciate you being here. Thank you for your time. Reach out to us if you have questions, refer us. We're happy to support our community in any way we can. Milan, did you have anything you wanted to say to close us out?
No, I mean, I'm honored to be a part of this community. I'm stunned by the legacy of strength and brilliance that we have, and I hope that you are every day reveling in that, no matter what the political opposition tells you, because we are fabulous. And I don't just mean that in the fashion and music and creative sense. I mean it in every way, in understanding how to create community, how to create belonging, how to create places where people thrive. We are great at that. And I want us to enjoy that and enjoy being with each other every day.
Thank you all so much for being here tonight. Thank you, Milan. Thank you, Monique, for supporting Equality NC and getting out the most timely information to our community. We hope you all have a great rest of the night and vote like your life depends on it, because it does.